Hello, everyone. Happy Wednesday. Thanks so much for tuning in. My name is Sarah Siegel, and on behalf of Harvard Bookstore, I'm excited to welcome you to tonight's event with Jamal Green, discussing his latest book, How Rights Went Wrong: Why Our Obsession with Rights is Tearing America Apart. He's joined in conversation tonight by Jill Lepore. Through virtual events like tonight's, Harvard Bookstore continues to bring authors and their work to our community and our new digital community during these challenging times. Every week, we're hosting events here on Zoom, and as always, our event schedule appears on our website at harvard.com/events, where you can sign up for our email newsletter and browse our shelves from home. This evening's discussion will conclude with some time for your questions. If you have a question at any time during the talk, please go to the Q&A button on your screen, and we will get through as many as time allows. If you'd like to buy a copy of How Rights Went Wrong, there will be a link in the chat where you can purchase it. All sales for this link support Harvard Bookstore, so thank you for your support of community spaces like your local bookstore. There will also be a link to donate in the chat if you'd like to give additional support to Harvard Bookstore. Your purchases and financial contributions make this virtual author series possible, and now more than ever supports the future of a landmark independent bookstore. Thank you for tuning in support of authors and the incredible staff of booksellers at Harvard Bookstore. We sincerely appreciate your support now and always. And finally, as you may have experienced in virtual gatherings these last few months, year really, technical issues may arise. If they do, we will do our best to resolve them as quickly as possible. Thank you for your patience and understanding. Now, I am so pleased to introduce tonight's speakers. Jamal Green is Dwight Professor of Law at Columbia Law School, a graduate of Harvard College and Yale Law School, and a former law clerk to Honorable John Paul Stevens. He was a reporter for Sports Illustrated from 1999 to 2002. He lives in New York City. He is joined tonight by Jill Lepore, who is the David Woods Kemper Class of 41 Professor of American History at Harvard University and a staff writer at The New Yorker. Her many books include The Secret History of Wonder Woman, a national bestseller, and Book of Ages, a finalist for the National Book Award. She lives in Cambridge, Massachusetts. Today, they are discussing how rights went wrong, why our obsession with rights is tearing America apart. Rights are a sacred part of American identity, yet they are also the source of some of our greatest divisions. We believe that holding a right means getting a judge to let us do whatever the right protects. And judges, for their part, seem unable to imagine two rights coexisting, reducing the law to winners and losers. The resulting system of legal absolutism distorts our law, debases our politics, and exacerbates our differences rather than helping to bridge them. Nadine Strawson, past president of the American Civil Liberties Union, writes, "How Rights Went Wrong offers important strategies for advancing human rights in an era when the Supreme Court cannot be counted on to do so. Jamal Green has written a superb, important book, and a well-timed one in its plea that we not vest so much power in courts and that we secure fundamental rights through the political process rather than through constitutional litigation." With that, I will turn things over to our speakers. Jamal and Jill, the virtual podium is yours.
Thanks so much, and thanks everyone for joining us this evening. I wish that we were all together in the bookstore in the sort of stuffy, wintry, cozy place that is Harvard Bookstore with its little folding chairs. But it's a delight and an honor to be here with you virtually, and a really huge treat to have the chance to talk with Jamal Green, who I'm such a really deep admirer of, and super excited. Congratulations on the book, Jamal, and really looking forward both to our conversation and to the last 20 minutes or so of the hour, which we'll be leaving for Q&A with those who are in attendance. This is a really challenging book. I mean, it's eminently readable and fun and fascinating. It's just the kind of really energetic disquisition and investigation that's lavishly illustrated with cases and kind of compelling human stories. But I think it really does challenge some pretty deep assumptions that most readers have about how the law works and what rights are and what we fight for when we fight for rights. So I'm looking forward to the opportunity to draw you out a little bit on what the book actually does and is. So I wanted to begin by asking you to sort of lay out for us some of the stakes, which in my view are kind of so beautifully illustrated in the first couple paragraphs of the book. So I was wondering if I could ask you to start us off just by reading a small bit and telling us a little bit about the scope of the claims you're making here.
So thank you, Jill. It's great to be with you and great to be with all of you this evening. I am going to read a little bit from the book. I have my own copy, believe it or not. So I'll start from the beginning. You have the right to remain silent and the right to free speech, the right to go out and the right to stay home, the right to worship and the right to doubt, the right against racial or sex discrimination, and the right to hate, the right to marry and to have children, the right to divorce and to terminate a pregnancy, the right not to be tortured, the right to die, the right to vote and the right not to, the right to education and the right to homeschooling, the right to health and to refuse health insurance, the right to eat and to stop eating, the right to clean air and water, the right to smoke cigarettes, the right to buy what you need, the right to hoard, the right to work, the right to party. A performance artist named Karen Finley, best known for smearing chocolate over her naked body, claimed a right to National Endowment of the Arts funding. She lost. A conservative advocacy group called Citizens United claimed the right to use its corporate treasury funds to produce an anti-Hillary Clinton movie during her first presidential run. They won. Two Orthodox Jewish merchants in Philadelphia claimed the right to keep their store open on Sundays. They lost. Jack Phillips, a Colorado baker, claimed the right to refuse to make a cake for a same-sex wedding. He won. Two Missouri women, Joba Nyang and Tamika Steigers, claimed the right to braid hair without completing a 1,500-hour training course and obtaining a cosmetology license. They lost. A group of neo-Nazis claimed the right to unite, armed with racist propaganda and semi-automatic rifles in a public park in Charlottesville, Virginia. They won. A Louisiana man named Gregory Sibley claimed the right to food, clothing, and shelter. He lost. A Long Island man, James Maloney, claimed the right to use his homemade nunchucks to teach his Shafan Ha-Lavan karate style, which he made up, to his children. He won. Rights have gone viral. We debate policy in the language of rights. We speak solemnly of soldiers heading to battle to defend them. We wave the dog-eared constitutions that enumerate them. We kiss the hems of the robes of judges who recognize and elevate them. The Frenchman Alexis de Tocqueville wrote in 1835 that, quote, scarcely any political question arises in the United States that is not resolved sooner or later into a judicial question. That was hyperbole in his time, but it rings true in our own. Rights are the commandments of our civic religion. This book is about how to get them right and why it matters.
Perfect, thanks. So I think that casual listener might assume that this is a book that is it's sort of an attack on the proliferation of rights, but it's really not. It's not that we have too many rights, as you argue here. In fact, we should maybe have fewer. They just need to be weaker. But I want to get to that, but I just kind of want to put a place marker there because in some ways I think you could hear that almost as a curmudgeonly attack on this. There's just too many things that people are claiming rights about, but there's something infinitely more sophisticated in your analysis here. But I actually want to begin, since I'm a historian, with a historical argument, because the book's title itself makes a historical argument, how white rights went wrong. Okay, so when did that happen? What went wrong, and when did it go wrong?
So the basic problem of the book, and I think this comes out in the introduction, at least I try to have it come out in the introduction, is that what we hold sacred as rights and don't hold sacred as rights is essentially arbitrary, right? That we've taken away from questions about justice. We've gone away from those questions and focus on kind of legalistic questions about whether a right should be protected or not. And we end up having these kind of abstract conversations about what things count as rights and what things don't, instead of talking about facts, which are essential to working out the rights that we have. And so that's just a setup. When did that happen? Well, it didn't. I'll tell you where it didn't happen, because whenever I make this claim, I hear a lot about the founders, and I hear a lot, often about the Declaration of Independence and the importance of those unalienable rights. to life, liberty, and the pursuit of happiness. And we've been a people who has cherished rights and has thought of them as basically absolute since the founding. We're told that's the story we tell about ourselves. But the Declaration of Independence took rights seriously, as I do, cared about rights as I do, but the way in which it contemplated realizing rights was not, federal courts and judges declaring the rights of individuals against the rights of communities. The very next line after that famous line about unalienable rights in the Declaration of Independence is that to secure these rights, governments are instituted among men. It marries, the founders at least, married the idea of self-government to the idea of rights. Government is how we achieve rights. And so what they're worried about, and this plays out in the Bill of Rights as well, what they're worried about is outsiders to the community, factions, external actors, taking away rights by taking away those institutions of self-government. So what happens? How do we get from a place where we marry self-government and community to rights to now? Well, the framers' vision was highly problematic because the framers were highly exclusionary, right? So they didn't have a genuinely pluralistic society. At least they didn't give political power to enslaved persons or to women or to people without property or to indigenous populations. And so a lot of the rest of, and I'll oversimplify, which I definitely have to say to an historian, but a lot of the rest of American history is trying to reconcile that initial commitment to self-government with genuine pluralism. So how do we protect rights in an inclusive way? And so that's the problem that the book is trying to address. I don't think we've gotten there as a country. And where we've gotten instead is a place where we've got judges who understand their role as declaring the rights of individuals in a way that's antagonistic to self-government. It's antagonistic to governing institutions. And the root of that, and I'll shut up after this, the root of that is, I think, largely to do with the grounding of our modern rights tradition in the civil rights movement, and in particular in claims about race. Now, that may seem bracing, right? Because that's something to be celebrated, is the Brown versus Board of Education and strong civil rights protected by heroic, courageous judges. But what that does is it associates the very idea of rights with an abusive, pathological government. And so where we've gotten today is to associate the idea of having a right with the government has wronged you. And so there's genuine antagonism between governance and rights. That may work if your only case is Jim Crow, where you really do need to not trust the government and you really do need to be antagonistic to those governments. But most rights don't look like that, or most cases, most claims of right don't look like that. Most claims of right arise out of government, people who are governing themselves and trying to achieve some important end, often an end that is itself rights protective. So you've got a very complicated world and a very binary, legalistic, kind of abstract way of thinking about rights that we've inherited from the civil rights movement.
So I take that, though, your book really does offer a kind of origin story. As much as it's also an argument against a certain kind of originalism, it offers its own origin story, which I took because I'm attracted to so much of the history that in the book that precedes the civil rights movement, that the origin story is not that civil rights lawyers are bringing rights cases to the court, got rights wrong, and therefore deformed our system of rights, but that the courts deformed rights long before then, such that the only solution for the civil rights movement was to go to the courts. So you say in your introduction, getting race wrong early has led the courts to get everything else wrong since, that the how rights went wrong argument, and here I'm just asking if I've got this correct, is so the founders didn't get rights wrong. The founders got government wrong because it was an exclusive constitution. And in that context, the courts then worked to ensure that people who were excluded couldn't find a way into the polity, and denied them rights. And therefore, the only way to get into the polity and become a full citizen in the political community was to bring rights cases to the courts. And that is the origins of what you call rightsism and the rights absolutism that now across the cultural landscape, throughout our polarized politics, looking at the many deformities of our federal system, that these things are all kind of knock-on effects from this kind of original sin. Is that a fair statement?
Yeah.
A recount of what you're arguing here?
Yeah, so let me give the story just a little bit more texture to make sure that I'm understood. So I'm not suggesting that the civil rights lawyers of the middle of the 20th century are responsible for the problem that I'm identifying. I do think that the way in which courts responded to race claims and how that differed from how they responded to other kinds of claims is a part of the story. So 14th Amendment and other Reconstruction era amendments that post-date the Civil War are transform the way the US Constitution relates to rights. Right? So puts in place individual rights, which are designed for primarily for former enslaved persons to be integrated into the political life of the country. That's repurposed after Reconstruction so that those rights that are in the 14th Amendment, so the 15th Amendment, which is about voting rights, is just ignored. And the 14th Amendment, which is more expansive, is not ignored. It's in fact used by businesses primarily to resist labor legislation, to resist health and safety measures, to resist unionization and collective bargaining. And that is viewed by the middle, I'm glossing over a lot, but that's by the middle of the 20th century, that's come to be understood as a mistake. So what you have is two kind of baskets into which you can put rights claims. You can put them in the basket of, we're trying to claim a kind of economic set of rights, rights against, which would have been understood then as rights against rights to contract, rights to certain kinds of property rights, rights against the social welfare legislation. Those aren't really rights. We come to believe, following the progressive tradition, come to believe that those aren't constitutional rights. So that's one basket. You're trying what lawyers refer to as ordinary social and economic legislation. You just defer to the government on those sorts of things. On the other hand, the other basket, you've got civil rights. The leading example being Black civil rights in the Jim Crow South, but also, you've got McCarthyism, you've got religious freedom claims as well, and those are quite different from the wage and hour claims that are being rejected as rights. Those are claims against a government that's entirely denying the citizenship of some of its people, right? So that's what real rights are on this view. So middle of the 20th century of this view of the real rights are the pathological abusive governments, and you don't have any rights outside of that context. So that's a very stark binary. But by the 1960s and 1970s, you get all sorts of people making rights claims. You have the women's rights movement, you've got the sexual revolution, you've got criminal justice revolution and changes in how we treat people who are incarcerated or facing incarceration. You've got a whole new generation of free speech claims, so claims on campus and the Vietnam War era claims about speech and people claiming to be free from defamation suits and all kinds of really textured freedom of speech claims. You've got claims for government welfare, right? So people who are saying that before you take away my welfare benefits, you've got to give me some due process. right? So a whole set of rights, and of course, when we get into the 70s, you have race-based affirmative action claims and abortion rights, which are not the sorts of things. None of these things are the sorts of things where you want to say, no, we just defer entirely to the government. There's no interest at stake at all when someone makes a claim about abortion rights or birth control, or but it's also not necessarily quite the same thing as an overt intentional denial of citizenship to part of the population. There's a lot more texture there, but our frame is still this kind of two basket binary frame that we still haven't quite gotten away from, right? So what the book is kind of complaining about is that rights overlap with government, rights overlap with politics, but by placing them into the hands of judges who are thinking in this very binary way, we actually take something away from politics. These are what political conversations should be about, and we put them in the hands of people who are viewing them in a very kind of abstract way. So I get a conflict over campaign finance and corporate, can corporations spend lots of money on political campaigns? And I, as a judge in the American system, I see that as a clash between freedom of speech and political equality. I've got to choose between one of those things, and I choose freedom of speech because that's I see that there in the First Amendment, as opposed to seeing that kind of conflict with much greater texture. And I could talk about ways in which that the conflict in Citizens United, which is the case I was referring to, is a much more textured case, and is actually the result of, and should be talked about in the language of politics, the language of negotiation, the language of mediation, rather than the language of let's choose one value or another, which results in polarization and alienation from the constitutional system.
So I want to come back to your analysis of Citizens United, but I think maybe to help shake loose the viewers who think the two baskets still make sense, right? Or it's very hard to imagine what else there is besides these two baskets. I was hoping you could tell us a comparative story that would maybe help to illustrate the other options that are not trapped in this absolutism, where we could see some of the ways of thinking, that you're talking about this evening as a kind of textured analysis through, proportionality or reconciliation or arbitration. Like, what are like we talk about the right to feed pigeons, or is there a case you want to from another country? Because one of the things that's so rich and provocative about this book is how seamlessly you bring into your own analysis comparisons of how courts work and how rights cases are resolved in other parts of the world, and many places where you suggest that these forms of analysis are far more consistent with the framers' view of what the relationship is between rights and government than our own contemporary Supreme Court's analysis. So, is there a story you can tell us that gives us a comparison point with an eye that I want to go back to Citizens United, but sort of fortified with a greater perspective?
Sure, and I'll just preface this by re-emphasizing what Jill emphasizes here, which is there are a lot of comparative examples in the book, and part of the reason there are a lot of comparative examples is not because other places always get this right. They don't always get this right, but the frame of mind that I'm trying to encourage here is much more common and much more intelligible in the rest of the world. So what I'm describing is fairly uniquely American. So it's not as if it's something that's truly exotic. There are models to look to. What I'll mention as briefly as I can, because it's a complex story, is abortion rights, which is the kind of model irreconcilable conflict within the U.S. But it turns out, for lots of reasons, to be clear, but it turns out that abortion rights are not nearly as controversial in most of the rest of the world as they are in the US. They're quite controversial in South America, they're quite controversial in the US, But in Canada, it's like not part of the constitutional debate anymore. In much of Europe, the same. In much of Asia, the same. Again, for complicated reasons, but one of the stories I tell in the book is the kind of parallel but inverted universe that we see around abortion rights in Germany, where in the 1970s, this issue is more complicated, more controversial in Germany than it is in the United States. And now it's much less controversial. And there is in place today a political compromise that was referred to as the group bill in Germany around abortion rights. It is today easier to get an abortion in Germany than in most states in the US. It's cheaper in most places than most places in the US. And yet that happened notwithstanding that the German courts started in the 1970s from a premise of the constitutional value of fetal life. So when I talk about inverting Roe versus Wade, the famous US case, is the court reviewing abortion restrictions in Texas and in Georgia and saying because of the importance of the autonomy of women, these restrictions have to be struck down. And in the course of doing so, the court says, and we must reject the idea that fetal life has any constitutional status or value. And the court says the reason we have to do that, the reason we have to reject that premise is because it's inconsistent with women's autonomy, that would decide the case. So that's a model of what I'm kind of pushing back against, is that we can state these values conflicts at a high level of generality and then decide cases in that way. So what the German court does is it says, well, no, fetal life. So they're dealing with a liberalization law, not a restriction, right? So the German legislature has liberalized access to abortion, and Christian Democrats in Germany challenge that and say, this is not respecting the value of fetal life. And the German court accepts that. So that's a very conservative premise from a US politics perspective. But the court says, but of course, the legislature has to pursue that value and also has to pursue the value of women's autonomy. So how do you reconcile those? Well, you get into the details and you get much more textured. Court says, well, how do you protect, what do we tell the person who wants a restriction? Well, one of the things we tell them is if you want to protect fetal life and also protect women's autonomy, the way to do that is to give women choices. And the way you give women choices is to focus on, to pour resources into pregnancy and childcare and employment guarantees, right? So that people choose life over termination. And they, of course, tell the other side something similar, which is, look, the way that, if there's, you actually have to focus on facts. So how are people actually going to respond to the abortion regime in place? Long story short, is you get to a political compromise. Not going to make everyone happy, but what you don't get is sort of apocalyptic clashes over, are you going to be on the fetal life side, anti-abortion movement in the US, or are you going to be on the women's choice side? And that's a way of courts ratcheting up and turning up the temperature of political conflict. And what the book is trying to show is ways of turning the temperature down, which means restoring some of these conflicts to politics rather than outsourcing them to sort of binary choices by judges.
Okay, so great. So now that we have that model on the table, as something that we can imagine, because I think it's really hard to imagine something other than the court says, Jamal, your rights are valuable, and Jill, your rights are not. Jamal, you get everything. Jill, you get nothing. Like, I think it's hard for us to think outside of that because we're so trapped in this particular dualistic logic about rights. Exactly as the way, that's the work that your book does so brilliantly, is render that visible to us, right? So I wanted just for everybody to be able to see a different way of looking at a problem. So let's go back to Citizens United. I would like to hear your analysis of a way that case could have been resolved in a way other than the way it was resolved? How
Oh,
could we reconceive of that as a political problem that can be solved through politics?
well, so so politics is part of what Citizens United is about. So there's a law in place, and the law says corporations can't use their general treasury funds to spend those funds on electioneering, which is putting out basically TV ads in the run up to an election. There's a company called Citizens United, which wants to put out an anti-Hillary Clinton movie just before the 2008 presidential election. So again, I think those of you in the audience who know anything about this case sort of understand it as we've got corporate speech rights on one hand, and you've got a law that's trying to equalize level the playing field so that TV ads aren't dominated by corporate money on the other side. And so we've got to just kind of line up on one side or the other. You believe in one or the other, and the court does that. So if you were to read Citizens United, you would see a court spending a lot of time talking about the value of political speech and saying there's no reason to deny that speech to corporations. And so once we decide that you can't deny that speech to corporations, then the case is decided. There's nothing else to talk about. And the court actually says that it's just that government trying to pursue political equality is illegitimate. Government just can't even pursue that objective at all. Now, if you ask me, a good old lefty, do you choose political equality or do you choose corporate speech? I'm going to choose political equality. I think that's the more important value because that's my priors. And if you ask someone who's more libertarian or more conservative, they're going to say something, it might say something different, right? Which is speech is important and corporations are just organizations of people who are trying to speak. And so political speech is really important. But the problem is, so that's the starkest, most sort of alienating way of talking about this kind of conflict. How else might you talk about it? Well, Citizens United is not General Motors, right? Citizens United is an ideological corporation. They're an advocacy group. They're a nonprofit. They're closely held. They're not traded on a stock exchange. So they're a very different kind of corporation than other kinds of corporations. So we might think that their speech rights are more important than the speech rights when it comes to politics and political issues of General Motors, for example, which would just be leveraging its profits for spending on elections. So should we not ask that question in the case? Should we not care about that distinction in the case? Should we care about the distinction between TV ads, which at least at the time of Citizens United involved a captured audience? You had to sit through these ads, versus video on demand, which is how this Hillary Clinton movie was put out. So you only got the movie if you asked for it, right? So that starts to look a little bit different. Should we ask about whether that difference should matter to a case like this? Well, maybe, but the court doesn't. Should we ask, what is the burden on Citizens United of putting this out through a separate political action committee, which the law allows them to do? Is that a burdensome thing or is that not a burdensome thing? Court never asks that question because we flattened the conflict into a conflict about speech versus equality. And so you ask me, a good old lefty, well, what if the case had said, well, in general, yes, corporate speech can be reined in through legislation, but if it's just video on demand and it's an ideological corporation and it's closely held, and they can show us that this is burdensome on them to create a separate political action committee, then they've got to get an exception from that. I could get on board, right? So suddenly you by looking at facts, you find consensus among people who disagree about the 20,000 feet stuff. But when you get down to the facts, there are actually a lot of consensus. I believe in political speech. I don't think all corporations should have their political speech restricted, but I also think political equality is important. So by asking the right kinds of questions, we can set some boundaries for the political conversation and say you can only go so far in either direction, but let's ask the questions that are actually about whether something unjust has happened here, as opposed to questions about conflicts of value. That's the book in a nutshell.
Okay, great. I want to go to questions from people in the audience in just a few minutes, but I want to, I guess, challenge you here with how we get to a court that works that way, or asks those questions, or how we get to a system where that case doesn't go to a court because there are other ways of resolving that conflict before going to the federal judiciary. I was trying to think before clicking on the Zoom link this evening about books that might be models for you that really made a splash and changed the nature of a conversation about how the law works and how the law should work. Because it seems like a very tall order here. And on one level, the thought experiment is thrilling. And that's one of the things I really enjoy about the book, is being asked to kind of really think through the possibilities of these things, of kind of escaping from this trap, turning something so brittle into something that could be flexible. But I wonder how you imagine getting there. Aren't there books that you can think of that do that?
So this is an interesting question. So law books that are completely transformative of the way we think about.
Yeah.
Well, I'll say a couple of things. So one is that most law books are written entirely for legal scholars. Not most. I shouldn't say most law books. Most law books that legal scholars read are written entirely for legal scholars, and most law books that judges who are engaged in some of the practices I'm criticizing read are written for a fairly narrow audience. So one thing I'm trying to do is try to make the stakes of this conversation more evident to people who are not inside law. And part of what I'm trying to do is to show the ways in which the way in which we talk about the justice of rights conflicts should be and can be continuous with the way that lawyers and judges talk about the justice of rights conflicts. So we should be part of a joint conversation. But the other thing I'll say two more things. So one is that I am an academic, and I measure success based on whether people are talking about me after I'm gone. Right. So I'm hoping that that's not for a while. And so I want you to ask me this in 50 years rather than next year.
Because but I do love that. I do love that idea. It's so consistent with the book that this argument must be brought to people who are not judges and lawyers, must be brought to all of us, so that we can consider the ways in which we are governing ourselves and choose and make different choices. So I love that the democratic sensibility of the book explains the existence of the book in a kind of beautiful way. We have a few questions here, so I'm gonna go to them, and then if we have time, I might follow up with one of my own. But I'm
Sure.
Sorry, I can barely read on the screen. But so the first is from Matthew St. Owens, who writes, "Two of the arbitrary rights you read about in the beginning," this was at the opening reading you did at the beginning of the introduction, "two of the rights are shocking in how opposite they are, the right to food and clothing versus the right to bring guns to a rally. Why is it that some people are so adamant about allowing rights to him at rallies while being downright heartless about something so basic as food and clothing?"
Well, it's a great question. I want to start answering a question like that by challenging the implicit premise, and I'm not suggesting anything about your ultimate beliefs. Was it Matthew? But the premise that we have to decide whether we are a society that believes in food and shelter and clothing, or whether we're a society that believes that people have a right to bear arms. That's the the premise, the kind of premise that I'm trying to challenge, which is if courts believe that they have to choose one of those things, well, they are conflict, people have different views about these things. The ways in which US courts have responded to things like rights to food and shelter and clothing is to say, well, rights are sacred and rights are presumptively absolute. And so you can't have an absolute right to food, shelter, and clothing. That creates some kind of socialist mandate. That's not what we're about. And so therefore, there is no such right. Whereas if you claim a right to bear arms, well, it's right there in the Second Amendment. It says you've got a right to bear arms. And so there, that's the system we have. Now, so that's a why. The question then I think becomes why not treat those rights in that way? And what I'd say is that there is nothing, and you'll have to trust me on this because we don't have time to get into it. But there's nothing in our Constitution that either requires us to understand the right to bear arms as anything like an absolute right, and certainly nothing in our history that would suggest that. And there's also nothing about our Constitution that precludes the idea that there's a right to food or shelter or clothing. And in fact, I'm going to surprise you and tell you that we actually already believe that we have those rights because if the government passed a law saying you may not eat, every judge would say that that's unconstitutional, even though that's not in the text of the Constitution. So we do believe in those rights, but we don't realize that we believe in them, right? So what I'm suggesting is that instead of saying we have to choose, that we either have the right or don't have the right, let's concede that these are really important interests. Some of them are in the Constitution, so the right to bear arms is more specific than most rights in the Constitution. And then let's talk about the things that matter and the things that we actually disagree about, which is what do we do with those rights? So someone passes a law saying it's really hard to get a concealed carry license. Well, what's the government trying to do? What's its evidence for imposing this burden? How burdensome is it on people? Could the government achieve its objectives in ways that don't impose those burdens? Right? Those are kind of retail questions. They're not wholesale questions about whether there's a right to bear arms or not. And we could do the same thing with rights to food and shelter and clothing. If the government is depriving that right in ways that are inexplicable or that are callous, that's the relevant question, not whether there's a right in the first place.
Juan has asked a question that I take to be whether rights absolutism is driving polarization or whether polarization has created rights absolutism. Not finding a middle ground in disputes about rights, is it the Supreme Court's fault or at large the rights discourse's fault, or is it a problem of the political system with only two parties that have very divided ideologies?
So I'm not going to give you a complete account of why we're polarized. I will say that the book is not a full explanation for that, and I wouldn't suggest that it is. What I would suggest is that judges and the way we think about rights makes it worse. And there's an opportunity here, not a complete opportunity. Nothing. If this book is 100% successful, we will still have significant polarization, right? But one of the hopes is that a lot of that polarization gets worked out through politics rather than in courts, right? But it's also I have a prediction based on what I've observed, right? That when you and I just gave the example of Citizens United, but I could do the same kind of analysis with a dozen other conflicts. That when you take a step back from this binary and start to ask much more specific, much more factually sensitive questions, that we agree on a lot more. And once we agree on a lot more, we can actually engage in politics. Now, so the prediction is that judges have an opportunity to help make our polarization better, but instead they're making it worse. And if they do the sorts of follow the kinds of strategies I suggest, they can make it better. How much better? That's hard to say, but better, and that's good enough for me.
Michael Smith writes, this sounds like a jurisprudence of 1, judicial modesty, and 2, prudence or even pragmatism. Is this similar to the incrementalist minded approach of Edmund Burke and other English conservatives? And then this is sort of a two-parter. In departing from universalist human rights, what does your approach leave behind and at whose expense?
So those two parts those two parts are different from each other. So let me try. Am I incrementalist, maybe minimalist, Burkean, conservative? Yes and no. Yes, in the sense that I think you're right that the book is in the spirit of judicial modesty and judicial humility about the capacity of judges to resolve certain kinds of values conflicts. And so for that reason, should introduce strategies that create more dialogue with political actors and institutions. So in that sense, yes. That said, I'm not, this book is not just sort of anti-judicial review or anti-strong judicial review. So in the sense that I do think there are circumstances under which judges should be quite robust in the way they approach conflicts. But those situations are marked out by the burdens imposed upon the people affected by the government's actions. So just to take the classic example of Brown versus Board of Education, I don't think that the right answer in Brown versus Board of Education is, well, let's think about the associational rights of the white parents in Topeka, Kansas, and let's think about the equality rights of Black children and see how we can have these things live together. Because I do think that that's a circumstance under which the correct judgment would be to say that there is an essentially unjustified and large burden being placed on an entire population of people. And so that's when judges really do need to say, this is a government that's fundamentally illegitimate in what it's trying to accomplish here. That's also going to be a judgment call, right? So I'm not suggesting that that any of this is easy, but that's the judgment they should be making. They shouldn't be making the judgment of, is there a right at stake? Because that doesn't get us anywhere. Or is race at stake? That also doesn't get us very far. We have to be talking about actual burdens and actual governmental motives. On the second question, where does that leave us if we get to, so I'll paraphrase and hope I'm getting this right, but if we there's a way of reading my argument as suggesting that rights are not that special, that there's sort of ordinary interests that people have, and the human rights discourse over the last 70 years has pushed back on that notion that human rights are actually important and unalienable, and we have to identify them because it's quite a serious thing when they're taken away. There's a few ways I could say, there are a few things I could say about that, but I think the important point to make is that this book is about how we organize ourselves politically. It's about who decides questions of value. It's about how do you construct a system of legal decision-making in the face of radical pluralism, and rights conflicts that are spoken of in the name of rights arise because we are different from each other, right? They don't arise, at least they certainly don't only arise because someone has been wronged. It may well be that rights are engaged and yet no one has been wronged, because we also live in a society. even though we pursue different commitments and ends. So this is about what do you do with legal decision making in the face of that fundamental pluralism and disagreement. It's not about, well, what counts as a right in some essential sense. What would a philosopher say about what rights we have and don't? I'm not that interested in that question because philosophers are not making legal decisions. People who exercise the power of the government, judges included, are engaged in what the legal scholar Robert Cover identified as acts of violence against people. And so when you engage in acts of violence against people, you have to have an eye towards how do we live together as a society, and not just have a moral theory of what counts as a right or what doesn't.
So I'm going to jump the queue here because I did want to ask you, just thinking about this question of judicial modesty and judicial humility and who decides. I did want to ask you about the Facebook so-called Supreme Court, and whether you think, because from the outside, those look like questions that can be framed in quite absolutist, rightist terms, to use your term, conflicts between free speech and the freedom not to be overwhelmed with misinformation about vaccination. Is it a judicial body that you think is acting in ways that are consistent with the vision that you have for how such disputes ought to be resolved and reconciled, or is it an example of how things don't work?
So when Jill refers to the Facebook Supreme Court, she's referring to the oversight board, which is a body that I sit on and co-chair, that decides, it's basically a body of last appeal for content moderation decisions by Facebook. And so the short answer to your question, Jill, as to whether it falls into these pitfalls or not is, I don't know yet, because we're a very young institution and we're still working our way towards something. But the board and Facebook, decisions that Facebook makes about content do, I think, engage some of the issues of the book, in the sense that, and you see it in the political conversation around content moderation, is that you get one side saying, Facebook is censoring, what happened to free speech? And another side saying, Facebook's a private company. Facebook can do what it wants because it's a private company. And I think that's too simple, insofar as, so Facebook's censoring of things is not the same thing as the government censoring of things. Facebook is a platform. They've created a platform and they have rules for that platform. And I think even if the government created a platform, they would be treated differently in that context than they would be treated if they're putting people in jail for what they say. So if I say, I'm going to start a newspaper, letters to the editor should not contain, hardcore sex talk. If you say that's not censorship, even if the government did it, that wouldn't be censorship. Well, it is, but it's a different kind of First Amendment problem than the government just deciding who gets to speak and who doesn't, on penalty of jail or something like that. Right. So at the same time, yes, it's a private company, but it's a private company with 3 billion users around the world, and that controls the internet in a number of countries. So it's also not quite so simple to say, well, it's just a private company. It's a private company that has the capacity to control the speech environment. So the question, it has to focus on that ultimate, essentially factual question. Well, how much is it controlling the speech environment? What choices are actually available to people who want to speak? What is the quality of that environment, that speech environment? Those are hard questions. They're questions that require the exercise of judgment. They're questions that require lots of facts, right? But those are the questions that are relevant to the justice of what Facebook is doing, rather than, is it a private company or is it regulating speech? Yes, of course, it's both those things.
I guess I think we have time maybe for one more question. I'm conscious that we just have a few minutes left here. But my response to your answer about Facebook has to do with why a quasi-judicial body rather than legislative solution. So I'm going to just kind of maybe throw that out on the table and then ask a question that had been raised by an anonymous attendee, because I often find at these events that all the questions are raised by men, which is the case in this Q&A, and I'm hoping anonymous might have a different voice, but I don't know. In Professor Greene's view, how should the issue of judicial deference to the legislature be approached, given his argument that the political branches should be engaging with constitutional questions instead of the judiciary? Under his preferred framework, when would it be appropriate to apply heightened scrutiny to legislative justifications, and how would it differ from current jurisprudence?
So on heightened scrutiny, and those of you who are not lawyers, this is the framework that courts apply when they are trying to communicate lack of deference to the legislature. So when should there be lack of deference to the legislature? I would say I don't love the and part of the book is not doesn't use the terms tiers of scrutiny very much, but I'm not a fan of the terminology of heightened scrutiny, because I think that scrutiny of government action should depend on whether what the government is doing is bears indicators of trust or not, rather than sort of predetermining. Right now, it's so: are they discriminating on the basis of sex or on the basis of race, or are they, engaging in content or viewpoint discrimination when it comes to freedom of speech? Those are the kinds of questions that lead to heightened scrutiny. In our current framework, I would say, well, let's talk about what the government's objective is, right? That's the first question. Is it doing something that within our society we understand to be a legitimate governmental objective? Is it relying on evidence? What did its process look like? What is the degree of burden on the people affected? Are there ways of achieving the same governmental objective without those burdens being imposed on people? Did the government consider those alternatives? What did it say in response to them? Right, those kinds of questions. If the answer to those questions is, well, it's just haphazard and it's very burdensome and it's not really pursuing something that seems to be of high moment within our society, that's reason to give less deference to the legislature, right? So it's to say, focus on what they're doing and how they're affecting people. Those are the questions that matter, as opposed to a kind of predetermined category. Now, back to Jill's question about the oversight board, why a judicial body rather than a legislative body? I can give a kind of an unsatisfying answer to that question. I'll just say it's unsatisfying answer to that question, which is that the problem that Facebook, an institution like Facebook, presents when it's regulating speech, and is that we don't trust it. We also don't trust the government to regulate speech, because the government is biased when it regulates speech. Facebook has its own biases. Those biases are more financial and reputational than necessarily partisan biases, but we don't trust either of these institutions. So what the oversight board is trying to create is an institution that can be trusted. Now, whether it succeeds at that remains to be seen, right? But what it tries to do is sever, we're independent of Facebook, so sever ties to Facebook. Pick people whose judgment is trusted within the realms they come from. But I don't know that we got it, necessarily get it right? So we're trying to design an institution that has the hallmarks of trust, that exercises its judgment in ways that are worthy of trust. And in some sense, that's the, you asked about a book, right? I kept, Democracy and Distrust kept coming to mind as the book that, gets cited in courts, and we think about that framework. This is John Hart Ely's book from 1980 about what do you do in the face of constitutional vagueness, essentially. And he said, what you do is you have judges step in when the government can't be trusted. Difference between him and me is that he wanted to think about that categorically, right? So he wanted to say there are certain situations when a discrete and insular minority is being affected, or when the government is engaged in self-dealing, when we don't trust it. Whereas I would say maybe those situations trigger distrust, but let's talk about let's talk more directly about what the government is trying to accomplish when we think about distrust. And it's very hard to work out those categories in advance. And if you say that judges are going to do it, that's giving judges a lot of power to decide really important questions on the basis of legal abstractions. So, is there a discrete and insular minority? So, choosing the category you put something in is all the power. And when judges make those judgments, we, the people who are not judges, should be able to scrutinize those judgments on the basis of things that are familiar to us, like, is this fair or not, as opposed to things that are unfamiliar, such as what do the framers think. That's a delegation of power to experts, and it's deeply problematic in a politically conflicted society.
Well, this has been fascinating. I'm going to end with my favorite line from the book, which I think carries forward some of the sentiment from your last answer. You write, outside the shadow of rights, folks usually kind of just work things out, which I loved for its democratic sensibility and its faith in people to resolve conflict and its willingness to accept the inevitability of conflict. So I wish we'd had a big argument here so that we could have demonstrated more conflict, but it's been a real pleasure to speak with you, and thanks everyone for questions, and apologies to people whose questions I didn't get to.
And thank you for coming.
I'm so sorry that we have to end now because we do have a handful more questions, but it is past 8 o'clock. So thank you again to Jamal and Jill for your time. And thank you all for tuning in and showing up for authors, publishers, indie bookselling, and our incredible staff here at Harvard Bookstore. If you would like to support Jamal and the bookstore, click the link in the chat to purchase How Rights Went Wrong. We sincerely appreciate your support. Thank you so much and have a great evening, everyone.